One.
Okay. Good morning. My name is John Rogers, and I'm an environmental manager with the Utah Division of Oil, Gas, and Mining. And I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. We are meeting in the DNR building in a very cozy setting, and we appreciate the division working this out. Our past room was taken, I believe. Today's Wednesday, January 15th, 2025, and this is the time and place for the hearing examiner's proceeding for docket number 2025-002, cause number 132-66, in the matter of the request for agency action of OVINTIV USA, Inc. for order pooling interest, including the compulsory pooling of the interest of certain non-consenting owners in the Beale, Utah 13-34, 4-3-3-10-7H well in a drilling unit established for the production of oil and gas and associated hydrocarbons from the Lower Green River-Wasatch Formation, comprised of all sections 3 and 10, Township 4 South, Range 3 West, Wind Special Meridian, Duchesne County, Utah. We're holding this hearing at the anchor position, the Department of Natural Resource Building in Salt Lake City, Utah. We are also hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? Do we see anyone online?
We do not.
Okay. And there's no one in the room, respondents that are interested in this proceedings other than participants. So we'll take appearance of counsel at this time.
Fred McDonald of counsel with Near and Lear on behalf of petitioner OVINTIV USA, Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining. And I'm also joined by members of the division. We have Peter Pinky, Colton Goodrich, and Regina Echo.
Yeah.
With me today.
Okay, thank you. And my counsel?
I'm Gary White, Assistant Attorney General, and I represent the hearing examiner today.
Thank you. I have received declarations for this matter from Mr. Ashley Ellison, CPL, Senior Landman Negotiator for OVINTIV USA, and Mr. Christopher Wall, Reservoir Engineer Advisor for OVINTIV. I reviewed both declarations before this hearing. Both these witnesses have been accepted as expert witnesses for past hearings. And do you wish to have them be accepted as expert witnesses in today's hearing?
Yes, Mr. Hearing Examiner, just for the record too, that Mr. Ellison will be recognized as an expert in petroleum land management, and Mr. Wall will be recognized as an expert in petroleum engineering and reservoir engineering.
Thank you. Does the division have any objections to these declarations and these individuals being qualified as expert witnesses?
No objections.
Okay. They are each recognized as experts in their particular field of study and work for this matter. Mr. McDonald, are these witnesses present today, and can we now swear them in? So
They are. If we would have you swear in the witnesses at this time, please.
okay. Please raise your right hand. Okay. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir, I do.
I do.
Okay. For the record, the witnesses have affirmed yes to the previous statement. We now will proceed to Mr. McDonald for his presentation.
Thank you, Mr. Rogers. Before we begin, I want to make sure that everybody received the revised Exhibit 7 that was filed yesterday.
I did.
Okay, and also confirm receipt of Exhibit 36, which was submitted on Monday. That's simply the reflecting the status of the certified mailings to the known compulsory pool parties.
Yeah. Division?
All right.
That's bad, okay.
Thank you. The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations at R649-2-8A and R649-2-9A. A copy of the request for agency action was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at issue at their last addresses disclosed by the relevant realty records and OVINTIV's internal records. In addition, notice of the filing of the request in this hearing was also duly published in the U.S.M Basin Standard on December 25th, 2024, and in the Salt Lake Tribune on December 28th, 2024. On January 8th, 2025, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request for agency action, and no other objections or responses to the request were timely filed. This cause involves the compulsory pooling of the drilling unit established for the Lower Green River-Wasatch production, comprised of the entirety of sections 3 and 10 of Township 4 South, Range 3 West, U.S.M, and Duchesne County. The drilling unit in a general regional map is shown on Exhibit 3, which is shown on the screen. As you can see, it is close to the Bridgeland community and is bisected by US 40 there. As evidenced by Exhibit 4, Section 3 is an irregular section comprised of 16 different lots. Section 10 is a regular governmental section. As a consequence, the drilling unit is comprised of 1,292.9 acres. The drilling unit was established by the board's order entered in cause number 139-150. OVINTIV is the majority working interest as owner as reflected in revised Exhibit 7 and in paragraph 11 of Mr. Ellison's declaration. This is the revised Exhibit 7, which I will get to later on as well. A true and correct copy of the 139-150 order was submitted as Exhibit 2. In accordance with the 139-150 order, Newfield drilled. Newfield was OVINTIV's predecessor by merger and name change. And OVINTIV now operates the Beal 7H well at issue here, with first production on August 4th, 2018. All is outlined in paragraph 3 of the request and paragraph 10 of Mr. Ellison's declaration. It is the only well currently on the drilling unit. Exhibit 5, which is shown on the PowerPoint, shows its general location within that drilling unit. And this also shows the different general mineral ownership within the drilling unit. As outlined in paragraph 6 of the request for agency action and paragraph 11 of Mr. Ellison's declaration, there are numerous other working interest owners in this drilling unit that have executed joint operating agreements, thereby voluntarily pooling their interests. There are 22 specific parties to be compulsory pooled and declared as non-consenting owners in the Beal 7H well. They are identified on page 2 of the request in paragraphs 13 through 32, 34, and 35 of Mr. Ellison's declaration. In the interest of brevity, I ask that you take administrative notice of those portions of the pleadings already on record in lieu of reciting all those parties now, but I can recite them if you'd like that.
I've read through those, have no issue, have division. No, that's fine.
All right, thank you. As evidenced by Exhibits 9, 11 through 14, 16 through 24, 27, 29, and 30, and is addressed in paragraphs 14, 16 through 19, 21 through 29, 32, and 33 of Mr. Ellison's declaration, the requisite notices of opportunity to participate in the Beal 7H well were provided and received by the parties identified therein, but none formally and timely responded. As evidenced by Exhibits 8, 10, 15, 25, 26, 34, 35, and Replacement Exhibit 31, and is addressed in paragraphs 13, 15, 20, 30, 31, 34, 35, and 37 of Mr. Ellison's declaration, the parties identified therein, if known, were also sent the requisite notice of opportunity to participate in the Beal well to their last known addresses, but were either undeliverable or refused, or we had no current address to send to. Pursuant to the board's order entered on December 12, 2024, all of those parties were also provided notice of opportunity to participate by publication in the Uinta Basin Standard on December 18th and 25th of 2024, but again, none formally and timely responded. As reflected in Exhibit 7, the aggregate amount of gross working interest to be compulsory pooled is 1.708197%. In addition, although OVINTIV believes it has leased all successors and voluntarily pooled their interest pursuant to the pooling clauses contained in the leases, except as to any party specifically identified in the request to claim through one of the estates and is to be compulsory pooled. There may be additional parties claiming by, through, or under certain decedents as identified in paragraph 36 of Mr. Ellison's declaration, whose estates have not been probated in Utah or are incomplete in distribution of subject mineral interests. Pursuant to the board's order entered on December 12, 2024, the requisite notice of opportunity to participate was provided to those parties by publication in the Uinta Basin Standard on December 18th and 25th of 2024. And again, no responses were received. Replacement Exhibit 31 in this cause is a true and correct copy of the affidavit of publication of the notice of opportunity to participate received from the Uinta Basin Standard. As reflected on Exhibit 32, and I'm going to show you the last page. In paragraph 41 of Mr. Ellison's declaration, the average weighted fee landowner's royalty as of the date of the spud of the Beal well was 18.443348%. As outlined in paragraph 43 of Mr. Ellison's declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners within the subject drilling unit. Their names and addresses were derived from a title opinion dated effective as of January 9th, 2018, as supplemented by a record search by OVINTIV's contract landmen and OVINTIV's internal records. As the record will reflect, none of the parties identified in the request as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance here today. Consequently, pursuant to Utah Administrative Code R641-104-150 and R641-108-400, OVINTIV moves to enter an order of default against them, and I would ask that the hearing examiner rule on that motion.
Okay, so accepted.
Thank you. Any objections from?
No.
Thank you. As evidenced by Exhibit 33, and as outlined in paragraph 5 of Mr. Wall's declaration, the actual costs of the Beal well were reasonably and necessarily incurred and were within reasonable variance of the AFE for the well. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Beal well is $75,000. Finally, exhibits 34 and 35 in paragraph 7 and 8 of Mr. Wall's declaration outline the risks assumed at the time of the spud of the Beal well. At this time, I'll commence my examination of Mr. Ellison. Mr. Ellison, would you please state your name and business address for the record?
Yes, sir. My name is Ashley Ellison. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
And what's your current position with OVINTIV and how does it relate to the drilling unit at issue today?
I'm a senior land negotiator with responsibility over this drilling unit, amongst others.
All right. Would you please state the corporate and bonding status of OVINTIV for the record?
OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production, Inc.
All right. Would you confirm for the record that exhibits 3 through 30 and 32 were prepared by you or by OVINTIV personnel or contractors with your review and input?
They were, sir.
And also, is replacement exhibit 31 an official business record of OVINTIV?
Yes, sir, it is.
All right. Would you confirm for the record that you have read and can confirm that all the statements made in your declaration are true and correct? Or
That
if
is
you have any modifications, would you do so at this time?
No modification. Sorry, Fred.
All right. Is it your expert opinion then that the terms and conditions of the joint operating agreement submitted as exhibit 30 are fair and reasonable and consistent with those executed by the other working interest owners in the drilling unit and those commonly accepted by industry and in particular in the Uinta Basin with respect to horizontal well operations?
Yes, sir, that is correct as well.
All right. With that, that concludes my examination, Mr. Ellison, and open them up to any questions from the hearing examiner of the division.
Okay, thank you. Division, do you have questions for this witness?
No, not anything specific, Mr. Ellison, just a general question. And I think we kind of ask this pretty regularly, but I noticed the well was spud in 2018. You guys got a title opinion back in 2018. It's indicated in your declaration that it reached payout in 2019. Letters to participate didn't go out till 2024. Could you just give us a brief explanation, kind of why the delay?
Oh, sure.
The delay?
Yeah, I mean, it's a logical question. We tried, I'm sure we tried to get a hold of everybody to lease them at the time. And then at the time, I wasn't around here. It's my understanding that it was there was just a lot going on at that time. Moving forward to today, we are trying to button up all of those well decks basically and try to figure out what to do with these unleased owners. So basically we tried to get a hold of them in 2018 and then additionally at present day, and we still can't find some people. So that's why we're now kind of coming back and force pooling this unit as well as a lot of the others, as you've seen.
All right, thank you very much. I have, the division has no further questions.
Yes, sir.
Okay. Yes, along those lines too, I was kind of curious. So this well has reached payout already, correct?
100%.
100%. So really there is no opportunity to participate, obviously. I mean, if it's already drilled and reached payout, that's still an option for people to back into this?
Well, it is to avoid a 300% penalty if they decided to participate at that time, and then they would pay their share of expenses going forward. Mr. Ellison, if I'm incorrect, please correct me on that.
No, it's true. I think these parties, if we can't find them now, we can't find them for the decks either. So, and at the end of the day, nobody normally, like, if I own minerals, I would not want to participate in a well because you just get bills every so often, and I don't want to pay those bills. So if these people by chance are back in 100%, they're also receiving bills that I would assume nobody is paying because we can't get a hold of anybody. So it's probably their royalties are probably simply being netted and then going into a suspense bucket because we can't find anybody.
Okay, so let me get this straight, and I apologize, I'm not think it's clear on this. But they know what production has been. They can see what's happened. Wouldn't it be their advantage to participate?
Well, they would. And the other problem is that, again, we don't know what the royalty is due them until they're compulsory pooled. So they get the royalty during the payout period. So they're entitled to that money. That's been suspended. And then once 100% payout, there would be a netting out of their expenses against the revenue, and that would be held in suspense too. But again, if they were to participate at that point and then go forward, if they're still not participating, which is what this hearing is about, the seeking is to get a 300% risk assessment award against them as well, which then would entitle them just to the royalty and not the remaining portion of it. But it's all held in suspense. So that's part of the reason they're bringing this all forward, is to get this all resolved as to what is the revenue that should be in suspense, what is the revenue that OVINTIV and the other consenting owners are entitled to if those parties are still deemed non-consent. Does that help?
Okay, so now let's look at it this way. They have reached payout, and so when you have a penalty, once you reach payout, don't you normally fall into as 100% owner?
You would. You get your 8/8 share of production at that point, but again, they've been netted out their costs of expenses against that revenue in the interim. But if it's 300%,
then it's going to be greater.
Yeah, it'll be a larger amount that's payable to the consenting owners.
Okay, I'm sorry, but
no, that's fine. I just want to make sure I'm not testifying. I'm just trying to clarify.
But this is a little bit different than most of them, you know, kind of
with the age on it. Yeah.
Okay. Yeah. Okay. Any more questions from the division?
No.
Okay.
All right. With that, I'll commence my examination, Mr. Wall. Mr. Wall, would you please state your name and business address for the record? Oh, I'm sorry.
Give me just 1 second to get here.
Okay, I'm sorry, I should check. Okay, let's move on, Mr. Wall.
Thank you. All right, again, Mr. Wall, would you please state your name and business address for the record?
Yes, my name is Christopher Wall, business address 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
All right, what is your current position with OVINTIV and how does it relate to this drilling unit at issue?
I am a reservoir engineering advisor with jurisdiction over this DSU as well as others in the Uinta Basin for OVINTIV.
All right, would you confirm for the record that exhibits 33 through 35 were prepared by you or OVINTIV personnel with your review and input?
Yes.
All right, would you also confirm for the record that you have read and you can confirm all the statements made in your declaration are true and correct? Or if you have any modifications, would you state them at this time?
Yes, and I do not have any modifications at this time.
All right, is it your expert opinion then that the costs of the Beal 7H well at issue reflected in Exhibit 33 were fair, reasonable, and necessarily incurred?
Yes.
Is it also your expert opinion that the Beal 7H well was economically feasible to drill, as that term is utilized in the 139-150 order?
Yes.
Finally, is it your expert opinion that the risks shown on Exhibits 34 and 35 justify imposition of a 300% risk assessment award and is fair and reasonable under the circumstances?
Yes.
With that, Mr. Hearing Examiner, that concludes my examination of Mr. Wall, and I would open him up for any questions from you in the division.
Division?
Yeah, we've reviewed Mr. Wall's declaration, and the division has no questions.
Okay, thank you. Just a thing on risk here. You know, we've been doing this a long time when we see that 300% risk is sort of the standard bar. And we look at the risk here, pretty much it's the same exhibit we see each time. Do we see anything that would reduce that risk over time that as you go forward with your experience in drilling here?
So, yeah, the more wells that we drill, obviously we get better understanding of what the structure is. And so those geosteering challenges can be mitigated. We can't, eliminate all risks. And then of course the business risks of, price uncertainty and such, we have no control over. So some risks do get mitigated over time, but I don't know that we can ever eliminate risks.
Okay, thank you. Gary, do you have anything? The division has filed a notice of non-opposition to the request for agency action dated January 8th, 2025. Mr. McDonald, we assume there are no more witnesses for you.
No, they're not, but at this point, what I was going to do is get the exhibits admitted.
Okay, you want to do that this
Yes,
time?
yeah.
Okay.
So I'm going to move for admission of exhibits 1 through 30, replacement exhibit 31, and 32 through 36, as well as Mr. Ellison's and Mr. Wall's declarations.
Division?
No objection.
Okay, so set.
Julianne, did I get them all?
Get on.
Yes,
Okay.
and administrative notice of,
Well, the pleadings themselves, so that I didn't have to recite all the names of the parties.
okay, thank you.
And that's
Okay.
fine, Mr. Rogers, and I'll just conclude after unless the division
Okay.
has any questions.
Julianne, you set then? You got everything you need? Okay. As I mentioned before, the division filed a notice of non-opposition on January 8th, 2025. Therefore, it's my understanding that the division has no objection to the request for agency action, but reserves the right to update its response after receipt of evidence and cross-examination at this proceeding. Is that accurate?
Yeah.
So this time I'll turn the time over to the division for any presentation they may have.
Thank you. As indicated in our response, the division, we've reviewed the requests and associated exhibits. We've reviewed the subsequently filed declarations, and it's the division's opinion that the petitioner has met the statutory and regulatory obligations for compulsory pooling, and we have no opposition at this time.
Okay, thank you. Gary. Okay, we'll take closing statements from the division and petitioner, and we'll start with Mr. McDonald, OVINTIV.
With that, Mr. Hearing Examiner, we again, just as the division has indicated, we believe we've satisfied all the statutory and regulatory requirements to grant the request as submitted, and we would ask that you do that. We also want to thank you, especially again for your time and effort in serving as hearing examiner, and to the DNR staff for making the virtual appearance by the witnesses available today.
Okay. And Mr. Haynes, you stated just recently that you have no opposition. Anything you want to add to that?
No additional information, but just echo the thanks expressed by Mr. McDonald.
I'd like to take a few minutes and talk with my counsel if we can, so we go off the record this time. Okay, in closing, we've already admitted exhibits, correct? So we'll pass on that. And I'd just like to summarize my decision here. As for agency action in all exhibits and having considered the evidence presented here today, I find that OVINTIV has provided sufficient notice of opportunity to the non-consenting compulsory pooled owners that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present in this well, and find that it would be appropriate to impose that requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that they are entitled to forced pulling of the named interest and other relief requested in the RAA. Mr. McDonald, will you please prepare order?
Certainly.
Okay. I will then present the findings and conclusions at the board hearing next week. Any other comments before we close? Okay. I would like to thank you for your participation and the division and department staff for helping us get this presented online. Thank you. We'll adjourn this proceeding at this time. Thank you.
Thank you, guys.
Okay. Okay, are we ready, Matt?
We are ready. We are still on air,
Okay.
on the record. Should I say?
Okay. Good morning. My name is John Rogers, and I'm Environmental Manager at the Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, January 15th, 2025, and this is the time and place for the hearing examiner's proceeding for docket number 2025-003, cause number 132-67. In the matter of request for agency action of OVINTIV USA Inc. for the order pulling interests, including the compulsory pulling of the interests of certain non-consenting owners in the Spear, Utah, 4-26, 3-2-26-35-17H well, in the drilling unit established for the production of oil and gas and associated hydrocarbons from the Lower Green River-Wasatch Formations, comprised of all of Section 26 and 35, Township 3 South, Range 2 West, Wind of Special Meridian, Duchesne County, Utah. We are holding this hearing in an anchor position in Department of Natural Resource Building in Salt Lake City, Utah. We'll also be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? Do we see any?
I will check and make sure, but there should not be. No, there are not.
Okay. Okay. Looks like there were no respondents. We'll take appearance of counsel this time.
Fred McDonald of Counsel with Lear and Lear on behalf of petitioner OVINTIV USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining. I'm also joined by Peter Pankey, Colton Goodridge, and Regina Echo with the division.
Thank you.
Assistant Attorney General Gary White for the hearing examiner.
Thank you. I've received declarations for this matter from Mr. Peter Burns, Land Advisor for OVINTIV USA, and Mr. Christopher Wall, Reservoir Engineer Advisor for OVINTIV. I reviewed both declarations before this hearing. Both of these witnesses have been accepted as expert witnesses for past hearings. And today, do you wish to have them accepted as experts in today's hearing?
Yes, again, and just for clarification of record, Mr. Burns would be recognized as an expert in petroleum land management, and Mr. Wall would be recognized as an expert in petroleum engineering and reservoir engineering.
Does the division have any objections to these declarations or these witnesses being accepted as experts?
They have no objection by the division.
They are then each recognized as experts in their particular field of study and work for this matter. Mr. McDonald, are they present today?
They are, and they're available for being sworn in at this time.
Okay, would you please raise your right hand? Okay. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Okay. For the witness affirms yes to the previous statement. At this time, I would like to acknowledge the receipt of 2 letters in opposition for this matter from Kimberly Richens and Julie Ann Moscato. It is my understanding that through counsel for OVINTIV that these 2 matters have been resolved. And at this time, would you like to address anything concerning those issues, Mr. McDonald?
Just briefly, Mr. Rogers, again, the parties did file formal objections and they were timely filed. I did have discussions with both, explained the legal circumstances and the status that they had, answered questions that they had, and both have now formally filed withdrawal of their objections on the record.
Okay. And I just wanted to go forth and present that in the hearing, so it was not front. Okay. We'll now proceed to Mr. McDonald for your presentation.
Thank you, Mr. Rogers. First of all, before we begin, I want to confirm that you received receipt of the revised Exhibit 7 filed yesterday, which is the gross working
Oh, yeah,
interest
okay,
summary.
that's the one. Yep.
Yeah, okay. Just to advise you that we will be having the need to revise that again, as we will explain through my summary and Mr. Burns's testimony. I also want to confirm that you received Exhibit 49 submitted on Monday, and that's simply the certified mailing filings and the status of those, so that's on the record now.
Okay.
The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and implementing regulations at R649-2-8A and R649-29A. A copy of the request was mailed certified mailing to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners in the drilling unit at their last addresses disclosed by the relevant realty records and OVINTIV's internal records. This included to the Ute Indian Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, Uinta Ouray Agency, and the Vernal Field Office of the Bureau of Land Management, which serves as the technical advisor of the Bureau of Indian Affairs, due to the tribal and allotted mineral ownership, and also to the Utah Department of Transportation and the Division of Forestry, Fire, and State Lands due to the state, the UDOT mineral ownership within the drilling unit. In addition, notice of the filing of the request and the hearing was duly published in the Uinta Basin Standard on December 25th, 2024, and in the Salt Lake Tribune on December 28th, 2024. On January 8th, 2025, the division filed a response expressing no opposition to the granting of the request. We've already addressed the 2 objections that were timely filed but have been withdrawn at this time. No other objections or responses to the request were timely filed. This cause involves the compulsory pooling of the drilling unit established for Lower Green River-Wasatch production, comprised of the entirety of sections 26 and 35 of Township 3 South, Range 2 West, in Duchesne County. If you look at Exhibit 3, which is shown on the PowerPoint here, you can see the location of it. The drilling unit incorporates a portion of the Mighton Town site and is also traversed by US 40. As reflected in Exhibit 4, the northeast quarter of Section 26 is actually comprised of 2 lots and that portion of the Duchesne River traversing it, but which nevertheless constitutes 40 acres. Section 35 is a regular governmental section, and consequently, the drilling unit is a regular 1,280 acre drilling unit. The drilling unit was established by the board's order entered in cause number 139-134. OVINTIV is the majority working interest owner, as reflected in revised Exhibit 7, although again, we will be needing to revise that again, as I will address shortly. This is also reflected in paragraph 9 of Mr. Burns' declaration. I want to go back to Exhibit 4 briefly, and again, to point out that the east half of Section 26 is actually within the Mighton Town site. With that brings tremendous amount of owners because it's the town site. A true and correct copy of the 139-134 order was submitted as Exhibit 2. In accordance with the 139-134 order, Newfield Production Company, OVINTIV's predecessor and title, drilled, and now OVINTIV operates the Spear 17H well at issue with first production on August 10th, 2018, as outlined in paragraph 3 of the request. There are no other wells located on the drilling unit. Again, Exhibit 5 just shows the general location of where the Spear well is.
Right here, we're looking up there at the east half of section 26. It says Ute Tribal Trust Minerals. And that's the town site right there, isn't it?
Yes, and
So the minerals are tribal, pretty much?
I would suggest you ask that for Mr. Burns, but I believe it's tribal land fee.
Okay, could we go refer to Exhibit 5 when we come back?
Right. As outlined in paragraph 6 and 7 of the request and paragraphs 9 and 11 of Mr. Burns' declaration, Duchesne County is a working interest owner in this drilling unit and has executed a joint operating agreement, thereby voluntarily pooling its interest. The Utah Department of Transportation also owns unleased interest in the drilling unit, but the Division of Forestry, Fire, and State Lands on its behalf yesterday formally ratified the recorded pooling declaration, thereby voluntarily pooling UDOT's interest with other fee leases. There's also my understanding that the tracks have been nominated for leasing by DFFSL and that will occur in the near future. There are 33 specific parties to be compulsory pooled and declared as non-consenting owners in the Spear Well. They are identified on pages 2 and 3 of the request, except as I will address shortly. And in paragraphs 14 through 16, 19 through 29, 31 through 43, and 46 through 50 of Mr. Burns' declaration. In the interest of brevity, again, I ask you, the hearing examiner to take administrative notice of those portions of the pleadings already on record in lieu of reciting all those parties right now.
Okay, I've read those and reviewed them. Division, do you have any issue with
No,
them?
that's sufficient for us.
Okay,
All right, thank you. As evidenced by exhibits 9, 11, 14 through 17, 19 through 23, 27 through 29, and 31 through 39, and is addressed in paragraphs 14, 16, 17, 19 through 22, 24 through 28, and 32 through 43 of Mr. Burns' declaration. The requisite notices of opportunity to participate in the Spear 17H well were provided and received by the parties identified therein, but none have timely or formally responded. As evidenced by exhibits 10, 18, 24, 26, and replacement exhibit 44, and is addressed in paragraphs 15, 23, 24, 26, 46 through 50, and 52 of Mr. Burns' declaration. The parties identified therein, if known, were sent the requisite notices of opportunity to participate in the Spear well to their last known addresses, but were either undeliverable or refused, or we had no address in order to which to send it. Pursuant to the board's order entered on December 12, 2024, all of those remaining parties were also provided notice by publication in the Uinta Basin Standard on December 18th and 25th, 2024, but none formally and timely responded. As reflected on revised Exhibit 7, the aggregate amount to be pooled is 0.098630. However, since we filed this exhibit, that changed again based on 2 other parties, which I will address shortly, and the actual gross working interest to be compulsory pooled is now 0.091804%. And we will provide a second revised Exhibit 7 post-hearing, if that's okay with the hearing examiner.
so it is 0.018.
1804, so it's
What was the
down,
original?
it's 0.98630
It's original.
as of 5 o'clock last night.
Okay.
So now it's changed again.
Okay.
Based on additional information we provide. I'll get to that in a second. As addressed in paragraph 12 of Mr. Burns' declaration, subsequent to the filing of the request in the exhibits, Kimberly Richens, aka Kimberly Dawn Richens, granted a lease to OVINTIV. Furthermore, after the filing of Mr. Burns' declaration, Jolie Opsahl, Bonnie Flesseris, Zemindar also granted leases to OVINTIV, and those are reflected on the revised Exhibit 7 that you see right now and that's been filed. Last night, however, we also discovered that Aaron Polson and Carrie Polson, Carly Polson, aka Carly Ann Williams, also leased, and that is the difference now that I've just discussed about in the interest.
Can I just add something here?
Yes.
Is this revision due to the petitioner asking them again, or did this actually just come in on their own accord?
They came in after the filing of the request for agency action
Mm-hmm.
in response. And so instead of agreeing or wanting to be compulsory pooled, they agreed to lease.
Mhm.
And OVINTIV is willing to do that so that they no longer need to be compulsory pooled, because OVINTIV has the right under the leases to voluntarily pool the interest.
Is that common to have them come in kind of last minute? That just seems odd to me.
It's happened quite a bit.
Okay.
As you can see, even through 5 o'clock last night, 2 more we discovered leased. So
Okay.
Sir,
that's what
could
happened.
you just repeat the 3? Was it Jolie?
Okay, it's Jolie Opsahl,
Uh-huh.
Bonnie Flesseris, who's
Bonnie
also
Flesseris,
Bonnie
okay.
Masquerada, Zemindar.
Is that a separate person? That's Bonnie.
That's a partnership. It's.
Oh, Zemindar.
Yes,
Okay, okay.
Zemindar. And then
Okay,
also,
gotcha, yeah.
like I said, what came in last night was Erin Polson and Carly Polson, who's also, I guess her name now is Carly Ann Williams. They came in last night. So all 5 of those, I'm gonna move at this point right now
Oh,
to
Erin.
remove them from needing to be compulsory pooled under the request for agency action.
All right, thanks, great. I got those.
And again, we will modify again Exhibit 7 to reflect the 0.019804% after, when I get out of here today.
Okay.
All right. Okay, in addition, OVINTIV believes that its leased all successors and voluntarily pooled their interests pursuant to the pooling clauses contained in their leases, and is otherwise expressly identified in the request to be compulsory pooled. There may be additional parties claiming buy-through under certain decedents as identified in paragraph 51 of Mr. Burns' declaration, whose estates have not been probated in Utah or are incomplete in distribution of the mineral interest. Pursuant to the board's order entered on December 12, 2024, the requisite notice of opportunity to participate was provided to them by publication in the Uinta Basin Standard on December 18th and 25th, 2024. No responses were timely received. Replacement Exhibit 44 in this cause is a true and correct copy of the affidavit of publication of the notice of opportunity to participate received from the Uinta Basin Standard. As reflected on Exhibit 45, which again I'll shoot to the last page. In paragraph 56 of Mr. Burns' declaration, the average weighted fee landowner's royalty as of the date of spud of the Spear well was 18.095235%. As outlined in paragraph 57 of Mr. Burns' declaration, the parties shown on the certificates of service filed in this cause are all of the production interest owners in the subject drilling unit. Their names and addresses were derived from a title opinion with an effective date of August 3rd, 2017, as supplemented by a record search of OVINTIV's contract landmen in OVINTIV's internal records. As the record will reflect, none of the parties identified in the request as amended today as being compulsory pooled and or declared as non-consenting owners in this cause timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R641-104-150 and R641-108-400, OVINTIV moves to enter an order of default against them, and I ask that the hearing examiner rule on that motion.
Division.
Yeah, no objection to the division.
Okay, so second.
Thank you. As reflected on Exhibit 46 and paragraph 5 of Mr. Wall's declaration, the costs incurred in the drilling of the Spear well were reasonably and necessarily incurred and within reasonable variance of the AFE. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging abandonment costs for the well is $75,000. Finally, as shown on Exhibits 47 and 48 in paragraphs 7 and 8 of Mr. Wall's declaration, the risks assumed at the time of the spud of the Spear 17 well are shown. With that, I'll commence my examination of Mr. Burns. Mr. Burns, would you please state your name and business address for the record?
Yes, Peter Burns, and OVINTIV's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
What is your current position with OVINTIV and how does it relate to the drilling unit at issue?
Sure, I'm a land advisor with OVINTIV with responsibility over this drilling unit, among others.
All right, would you please state the corporate and binding status of OVINTIV for the record?
Yes, OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to New Fuel Production Company and by merger of OVINTIV Production, Inc.
All right, would you confirm for the record that exhibits 3 through 6, revised exhibit 7, which we will be again revising, exhibits 9 through 11, 14 through 29, 31 through 39, 41 through 43, and 45 were prepared by you or OVINTIV personnel or contractors with your review and input?
Yes.
Would you also confirm for the record that replacement exhibit 44 is an official business record of OVINTIV?
Yes.
All right, would you also confirm for the record that you've read all the statements made in your declaration and that they're true and correct? Or if modifications are required, to state them on the record at this time?
Sure. I believe they're all correct with some of the, dismissals that you've discussed, namely Joey Opsal, Bonnie Flasuris, Zemindar, Aaron Polson, and Carly Polson. They've all since leased to us and therefore are no longer required to be compulsory pooled.
All right, the division in its memorandum wanted some clarification regarding exhibit 38 and specifically about Andrew Scott Klein and Tina Gubin, or Gubine, I guess is her name. Would you please address that right now?
Sure. The notice of opportunity was addressed to Andrew Scott Klein, but Tina Gubine is instead named as the party being compulsory pooled. Mr. Klein still appears of record as the owner. However, after mailing the notice, we discovered that he is deceased. Ms. Gubine is Mr. Klein's mother, and it appears she is his sole heir under the applicable intestacy law based on the information we have obtained. We then mailed an NOP to her. She signed for that, but she has not responded to our request for agency action.
All right. Also, Mr. Rogers, as the hearing examiner, had a question regarding exhibit 5, and in particular, the lands within section 26 that are within the Mighton Town site is indicated on this as U Tribal Trust Minerals. Is that the case, or do you need further clarification on that?
So yeah, that east half of section 26 is primarily tribal trust. However, that does get into the Mighton Town site. So there are very small lots and blocks of the ownership. And that was just, in hindsight, that was too difficult to put on this map here, but it is a mix of tribal and fee mineral.
I just want to understand that.
Right, and that's, I wanted to get him on the record with that, okay? All right, is it your expert opinion then that the terms and conditions of the joint operating agreement submitted as exhibit 43 are fair and reasonable and consistent with that executed by Duchesne County covering this drilling unit as outlined in paragraph 55 of your declaration, and also with those commonly accepted by industry, and in particular the Uinta Basin with respect to horizontal well operations?
Yes.
All right, with that, Mr. Rogers, that concludes my examination of Mr. Burns, and open him up to questions from you in the division.
Division, yeah, questions for Mr. Burns?
Yeah, just a couple questions, Mr. Burns. And this is probably already being addressed. I'd just like to get your response to this. I noticed in your declaration in paragraph 9, you indicated that unleased minerals represented, let me find it real quick, 0.235637%. You said subject to a revised exhibit. That number now has gone down quite a bit. Could you just explain the difference? I know we talked about some leases, but is that the only reason that dropped since your declaration?
Yes, it was really just revising some final review of the total numbers prior to the hearing after the declaration had been filed, but also then incorporating the changes we discussed of those parties who leased late. And so that's what takes it down to the reduced number of the 0.091804%.
Okay, thank you. Additionally, it's indicated that your title opinion was done in 2017. I know it's a small amount, but there is quite a few people that were unleased. What additional measures were taken between 2017 to 2024 when the election letters went out to ensure that you had correct, I guess, parties and addresses there?
Yeah, so I mean, we take that 2017 title opinion and bring it forward just via our land brokers, Lone Wolf Energy. Like it's not a full-blown new title opinion, but they review the records to bring forward the title so that it's current. We're also incorporating any changes that owners notify us of so that our decks are accurate. But that's really just I think that's the gist of it, is just the brokers help us bring forward the ownership so that it's as current as possible.
Additionally, there was the discussion about UDOT's interest being currently unleased. However, FFSL has ratified the pooling agreement or declaration. Could you just explain what the implications of that is? What does that mean if FFSL ratified that declaration?
Yeah, so whenever as we get closer to drilling a new well, we will file what's called a declaration of pooling that just, puts the public on notice of all the fee leases that we have at the time. So just, and that document gets recorded in the courthouse, and it just lists all of the fee leases that we have. Technically, since UDOT's interest is unleased, and there's a question as to whether or not they can be force pooled, we asked them to ratify that declaration of pooling, just to, effectively pool themselves into the SPEAR unit until that interest can get leased.
Okay.
We've nominated these tracts for lease. It's just pending getting a formal lease offer scheduled.
All right. Thank you, Mr. Burns. Just lastly, we already talked about the objections that were filed and subsequently withdrawn. Just for our understanding, Julie Mosquito, who filed the objection, was she already leased?
Yes, she was.
Okay. I didn't quite understand some of the stuff in the objection, so I just wanted that clarification. And with that, the division has no further questions.
Okay. Ms. Rogers, if I could just get a redirect to question, yeah, just to clarify too. Peter, is it also a situation when you talk about the difference between the title opinion in 2017 and bringing it forward, there's a lot of people in that Mighton Town site that died and trying to track down heirs when there isn't a probate. Is that right?
Correct. Yes.
So that also would account for the fact that there's a lot of other people that they've discovered based on information they've been able to determine since that time.
Sure.
All right. Thank you. That's all, Mr. Rogers.
Something interesting you brought up, Mr. Burns, is you said that UDOT was questioning whether they could be force pulled. Is that because they're a government entity?
There's a question about that. Let's just say Mr. Begley and I have had a difference of opinion.
And where will that be solved for the time being? Then they will be treated as leased then?
They're being suspended. The money's in suspense with the pooling, but until it gets leased, and then we determine who their lessee is and what the royalty is so that money can then be released. But by voluntarily pooling and committing the interest is voluntarily pooled, and therefore that takes it out of the need to compulsory pool it.
So this will be handled in another arena.
Right.
Okay. Interesting. I've never run into that.
It's come in a couple of times. We've tried to avoid having to do it in front of the board.
Okay. Got it. Do you have anything for Mr. Burns? Okay. Mr. McDonald, we'll move on to your next witness.
All right. At this time, I'd like to commence my examination from Mr. Wall. Mr. Wall, would you please state your name and business address for the record?
Yes. Christopher Wall, business address 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
And what is your current position with OVINTIV, and how does it relate to this drilling unit as issue?
I am a reservoir engineering advisor working this drilling issue as well as others in the Uinta Basin for OVINTIV.
All right, would you please confirm for the record that exhibits 46 through 48 were prepared by you or OVINTIV personnel with your review and input?
Yes.
Okay, will you also confirm for the record that you've read and confirmed that all the statements made in your declaration are true or correct, or if you need any modifications, to please state them at this time?
Yes, and I do not require any modifications at this time.
All right, is it your expert opinion then that the actual costs of the spear well as reflected in exhibit 46 were fair and reasonably and necessarily incurred?
Yes.
Is it also your expert opinion that the spear well was economically feasible to drill, as that term is utilized in the 139-134 order?
Yes.
Finally, is it your expert opinion that the risks shown on exhibits 47 and 48 justify the imposition of a 300% risk assessment award, and that it's fair and reasonable under the circumstances of the drilling of that well?
Yes.
Thank you. That concludes my examination, Mr. Wall. Mr. Rogers, and open him up to questions from the division or yourself.
Division?
The division has no questions for Mr. Wall.
I'd like to go back to the expense, cost expense. There we are. I noticed this one is in 10 million. It seems a lot higher than the other ones we've seen. Is there a particular reason individual as well, or is it geological engineering, or what seems to be different from the system?
Sure. The drilling and completing portion was actually roughly 7.3 million. The other, 3 million is coming from the operating expenses, which is just something that, obviously accumulates over time. In my opinion, the drilling and completion of this well at 7.3 is pretty good. It's not expensive in my estimation. So this well really went pretty smoothly for the time at which we drilled it, and under, not having drilled an upper Wasatch well, which is one of the deeper targets that we drill in the township, I think things went really pretty well.
So as we look at these costs, then the costs increase over time due to the operating expense on an annual basis?
Yeah, so it doesn't necessarily, well, obviously there's inflation, but I don't know that you would necessarily notice that on an annual basis. But you can see, like in 22, the LOE expenses or the operating expenses were 692,000. Most likely there was a workover on the well, and that those workovers are expensive when we have to move a rig onto the well to remove and replace equipment. Other than that, 300,000, 250,000, somewhere in that range is a bit typical for these wells in the basin. And that will fluctuate depending on some of the prices, like chemicals. We spend quite a bit of money on chemicals to treat these wells. So, and those can be tied to oil and gas prices. So, our expenses will fluctuate. The other big expense that we have is disposing of water, which tends to be fairly stable. However, we do have disruptions from time to time in our system. And so, we may have to switch and start trucking water, which can be very, very costly. So hopefully that helps.
Okay, and just to clarify again, the older the well, this well originally had some costs way back in 2012. It looks like it was drilled in 2018. But a younger well would not have those additional operating expenses over year. So really, to compare these numbers is like apples and oranges, essentially. Because you have longer terms of operating expense, more years of that. We're looking at that total number of 10 million. Is that making any sense? Or because you're adding that all in there?
Yeah, that's correct. So, we're obviously looking at, Peter can probably talk to this better, but I would assume that we're pulling from the start of the well. And so, yeah, we're accumulating all of the operating expenses from initial drilling to today through, and I'm guessing this is probably July. I have it in my notes somewhere, but I'm not didn't look it up.
It says October on the exhibit.
Okay, October.
Yeah. It also helps with payout. In other words, what is the payout? So as far as reaching 100 or 300% payout, you have to account for these operating expenses as
So
well.
you really can't compare these costs, because, you know, each one, that's what it costs to drill the well. There's other expenses that come into that in the future.
The operating expenses, yes.
Um, Again, I'd like to go to the page 6 of the request for agency action. Because this well achieved 100% payout on May 31st, 2019. Again, is this a situation where the payout was done and completed? You're still trying to force pull this?
Right. It's the same situation as we discussed in the last matter, that you have to go back to date of first production. And again, to deal with what the royalty is due at that time, and then to give the people the opportunity to avoid having the 300%. And it hasn't reached 300% yet. So it's a matter of trying to clarify what revenue is owed at that point.
And you need a force pulling order to
Yes.
sort out. all
To
those
determine what is that royalty that would be due during that 100% payout
Okay.
term.
numbers. Okay. At this time, anything else from you, Ms. McDonald?
No, that concludes our presentation, Chief. I would, though, move for admission of exhibits 1 through 6. Revise exhibit 7 with the understanding that we will again submit a second revised to reflect the numbers as of Mr. Burns' testimony.
And for my clarification on those, so we actually got 3 of them. Do you?
No,
know
you got
the original?
the original and a revised, and now we're going to do a third one.
What do you
Yes.
call the second revision?
Second revision.
Okay, just so I know how to
Yes.
look for it.
Yes. Okay, and then exhibits 9 through 11, exhibits 14 through 24, exhibits 26 through 29, exhibits 31 through 39, 41 through 43, replacement exhibit 44, and exhibits 45 through 49, as well as Mr. Burns and Mr. Wall's declaration. So we're excluding exhibits 8. Yes, exhibits 8, 12, 25, and 30 and 40. Is that right? I believe that's correct.
Addie, Julianne, did you get all that?
So it's, oh, excuse me, it's 12, 13, 25, 30, and 40 are not being submitted.
We good on that? She's still thinking.
Okay.
Division?
Yeah, with that, I'll wait and.
Yeah, no
with
objections.
conclusions.
We'll accept those as.
Thank you.
Okay, we'll now turn the time over to the division. They filed a response notice of non-opposition on January 8th, 2025. My understanding that you have no objection and you would reserve the right to review the evidence presented today. Is that accurate?
That's correct.
I'll turn some time over to you if you'd like.
Yeah, the division filed the response based on the RAA and the exhibits that had been filed at the time. In our response, we did indicate that we believe the petitioner had met the statutory and regulatory requirements for compulsory pooling. However, we did make our response subject to the objections being resolved by the date of the hearing. Our understanding these have been resolved. We have no further issue there. So with that in mind, and based on the declarations that have been submitted and reviewed, the division still has no objection to this RAA.
Okay. All right, thank you. We'll turn the time over to Mr. McDonald for your closing statements.
Thank you, Mr. Rogers. Again, we believe that we've satisfied all the statutory and regulatory requirements. We would ask that you approve the request as amended with the exclusion of those parties that have now leased. And we thank you again for your time to serve as hearing examiner. And also again, thanks the division staff for allowing a virtual appearance by Mr. Burns and Mr. Wall. And that concludes our comments.
Okay. Division, you presented just briefly. Do you have anything to add?
No additional comments.
Okay, thank you. Okay, we've admitted exhibits, so let's move forward with my summation. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that OVINTIV has provided sufficient notice of opportunity to the non-consenting, to the non-consenting compulsory pool owners, and that these owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present with the well, and find that it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that they are entitled to forced pulling of the named interest and other relief requested in the RAA. Mr. McDonald, will you prepare the proposed order?
I will.
Upon receipt of that, I will present the findings and conclusions to the board next week at their hearing. Any other comments before we close?
No.
Okay. And then one more comments. I'd like to thank you for your participation. Thank for the division staff for getting this online and presenting and preparing for this hearing. Thank you to OVINTIV and your participation in being online. That makes it very helpful. We'll adjourn this proceeding at this time.
Thank you.
Yeah.
Let's take 10 minutes.
Yeah, Mitch
We'll do a
needs to get
10-minute
set up.
break.
Yeah, Mitch, get set up here. Good morning. My name is John Rogers. I'm environmental manager with the Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, January 15th, 2025, and this is the time and place for the hearing examiner's proceeding for docket number 2025-008, cause number 132-70. In the matter of request for agency action for OVINTIV USA Inc. for order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Mamie, Utah 4-25, 3-3, 25-36, -46H well identified herein in the drilling unit established for the production of oil, gas, and associated hydrocarbons for the Lower Green River-Wasatch Formation comprised of all of Section 25 and 36, Township 3 South, Range 3 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this with an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. We'll also be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. Before we begin, are there any members of the public or respondents present that wish to comment at these proceedings? Do we see any there?
There are not.
Okay. We see none in the room today. We'll take appearance with counsel at this time.
Thank you, Mr. Hearing Examiner Mitch Mayo of Lear & Lear PLC on behalf of Petitioner OVINTIV USA.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining. And I'm also joined by members of the division, Peter Pankey, Colton Goodrich, and Regina Echo.
Thank you. And my counsel?
Assistant Attorney General Gary White on behalf of the hearing examiner.
Thank you. I received declarations for this matter from Mr. David Dale, Manager, Rockies Land for OVINTIV USA Inc., and Mr. Christopher Wall, Reservoir Engineer Advisor for OVINTIV. I have reviewed both declarations before this hearing. Both these witnesses have been accepted as expert witnesses for past hearings. Mr. Mayo, do you wish to have them accepted today as experts?
Please, yes,
Okay.
thank you.
Does the division have any objection to these declarations, or are these individuals accepted as qualified expert witnesses?
No objection. I was just checking who it was.
Okay.
I was making sure it was, I recognized who the people were.
Yeah, smart.
Okay, they will be each recognized as experts in their particular field of study and work for this matter. Mr. Mayo, these witnesses are here today online.
They are.
Okay. We'll swear them in at this time. Please raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes.
Okay. For the record, the witnesses have affirmed yes to the previous statement. We will now proceed to Mr. Mayo for his presentation.
Thank you, Mr. Hearing Examiner. You've covered a lot of the introduction, so I'll kind of jump quickly to where we are. First off, the board and the hearing examiner by designation has jurisdiction over this matter pursuant to Utah Code 40-6-6.5. This matter is mentioned by the hearing examiner as a request to compulsory pool the interest in a drilling unit established in sections 25 and 36 in Township 3 South, 3 West, related to the production from the Mamie 46H well as defined in the request for agency action. A copy of the request was sent by certified mail to the known parties sought to be pooled. And sent by regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records and OVINTIV's internal records. In addition, the request was mailed to all relevant federal and tribal agencies, specifically including SITLA, DFFSL, the BIA, and the BLM due to mineral ownership within the drilling unit. Before we get too much further, I'd like to note something for the record. There was something unusual happened in this matter that hasn't happened in the 10 years I've been doing this. As is typical in these proceedings, the board authorizes publication of the notice of opportunity to participate for those parties who have been unlocatable. The board did so and approved that in this cause, and OVINTIV proceeded to publish notice accordingly. Notice was scheduled to be published December 18th and December 25th, 2024 to meet the board's regulatory requirements of 2 consecutive weeks of publication. After the new year, when we went to print off the affidavit publication to submit as an exhibit, we uncovered that UInT Basin Standard had made some unknown computer error they couldn't explain, but said, it's our bad. We'll republish this for you January 8th and January 15th. Long story short, through no fault of OVINTIV's, the publication technically didn't meet the regulatory requirements of being published 2 consecutive weeks. It has been published January 8th and today is my understanding, but we will confirm that at next week's hearing. Regardless, given the complication with the notice and an effort to be as clear and transparent as possible and allow for as many objections, if any, as possible, OVINTIV pursuant to Administrative Code 641-104-100-160 and R641-105-300, which allows, quote, oral motions may be presented at the hearing. OVINTIV hereby makes an oral motion to continue the entry of this order from the January hearing to the February hearing. Essentially, we'll present all the evidence here at the hearing. The hearing examiner and the division, if convinced that we've met the regulatory requirements, will make the determination based on the request. The order will be finalized. However, the board won't sign or consider signing the order until the February hearing. That way it allows 30 days for anyone to object if they need to. And so on that basis, I'd make the motion to the hearing examiner to continue this to the February hearing following the presentation of the evidence.
Division?
Yeah, as indicated when we filed a response, we felt that the statutory and regulatory requirements were not met because of this publication error, but the solution proposed by council is acceptable to the division. If that we're in agreement with that.
Okay. Since we are gathered here today, ready to present this, we'll go ahead and hear evidence in the case. And then based on what I decided to end, provisionally accept this or deny it, whichever we determine. And then at the board, present that at the board next week, to say this is where we're going, and we're gonna wait 30 days and then to have them accept it or see what happens in that meantime. So we'll go ahead and hear it today, and I'll make a provisional decision today.
Perfect. Is that considered a grant of the motion then?
Yes.
Okay. Would you like me to file any sort of order memorializing that continuance? Is that necessary, or are we happy to have this and then the oral presentation at the board hearing?
I'll let the legal time, that's something.
I think if you present it orally to the board and its council can make that decision.
Okay. Between now and next week, no.
I don't think so. I don't think there's a reason to, unless the division has none.
I think it's fine just to do it in front of the board.
Okay.
We'll give board council a heads up.
Perfect. Thank you. Make a quick note. Thank you for that. In addition to notice of the filing of the request and this hearing, which was intended to be published and now has been published 3 weeks non-consecutively. This hearing was also, notice of this hearing was also duly published by the board division in the Uinta Basin Standard on December 25th and the Salt Lake Tribune on December 29th of 2024. On January 8th, as mentioned by Division Council, the Division of Oil, Gas, and Mining filed a response expressing no opposition to granting the request, but noting pretty clearly the regulatory failing resulting from the notice failure. Based on the motion that's been granted, subject to confirmation from division, I assume that that concern with the regulatory requirements has now been lifted. The division's position can be stated as not necessarily opposing pending the presentation of evidence here today. There were no other objections or responses to the REA that were timely filed and that remain pending. To summarize, this cause involves the compulsory pooling, as mentioned, of a 1,280 acre drilling unit established for Lower Green River-Wasatch Formation production of a unit comprising the entireties of sections 25 and 36, 3 South, 3 West in Duchesne County. This drilling unit was established by board order in July of 2015 in cause number 139-134. OVINTIV is the supermajority interest owner, as shown on Exhibit 8 and as stated in Mr. Dale's declaration. At the time the request was filed, there were 3 wells producing from the subject lands. The Lake Borum 4-36-3-3WH well, which was producing from section 36, and the Mamie 4-25-3-3WH well, and the Evans 14-25-3-3WH well, both of which were producing from section 25. By order, in cause 139-102, the board compulsorily pooled the interest of 2 owners, W. Gene Hansen and Pat Maxwell, in the section 36 unit with respect to the Lake Borum well. Full recoupment under that order has not yet been achieved, but further recoupment is waived pursuant to the 139-134 order. No compulsory pooling order was ever sought with respect to the section 25 wells, the Mamie and Evans wells, and any unleased parties in those wells were carried under common law co-tenancy principles. Any recoupment, if any, still owing under those common law principles are also waived effective the date of production from the subject well. Subsequently, pursuant to the 139-134 order on file as Exhibit 2, OVINTIV spud and has begun to produce from the Mamie UT 4-25-3, the Mamie UT 4-25, 3-3-25-36-46H well, API number 43-013-53896. This well was spud on December 17th, 2018, with a date of first production of November 15th, 2019. Accordingly, in light of these facts, OVINTIV requests that the 139-102 order be vacated insofar as it pertains to the unit comprised of section 36 and the pooling related to the Lake Borum well completed thereon. Based on the date of first production and the terms of the 139-134 order, conversion occurred as of December 1st, 2019. And to be clear, OVINTIV waives any further recoupment after that date.
Which well was converted?
All 3 wells were converted as of that date. And any recoupment owed on the Lake Borum well under the 139-102 order or under common law co-tenancy principles in the Evans and Mamie wells is waived effective that date.
So the Evans and the Borum well are in section 25.
Yeah. Evans and the Mamie are in section 25.
Yeah.
And the Borum is in section 36.
But so there'll be no more pooling for those. It'll be replaced by this if granted.
That's right. That's right.
Okay.
The pooling effectively commits them to the development, which they are. And by this pooling, they're now committed to the development a second time, just a different type of development. But it also accounts for the payout status. And because of the conversion orders that OVINTIV operates under, the spacing orders, they waive any further recoupment under that. So the only 2 issues in a pooling order, committing them to the unit and essentially how they get paid, those are both now addressed by this. So that old pooling order can be vacated.
Okay.
There are 4 owners or potential owners of undivided oil and gas interests in the subject unit and the subject well, who have refused or failed to lease or otherwise agree to pay their proportionate share of the costs of the well. These parties are all listed on page 2 of the request for agency action. I actually, because it's a fairly small list, I will read them for you. Those parties are Patricia Brown, Stanton W. Hansen, Stephen A. Hansen, and Susan Porter Hansen as co-personal representatives of the estate of Warren Eugene Hansen, Thunderbird Oil Company, and the trustee of the W. Gene Hansen Revocable Trust dated the 16th of December, 1998. In addition to those 4 potential owners, there are 3 estates named to be pooled in this request. The estate of Kelly Reese Claiborne, the estate of Lenora Reimansberger, and the estate of W. Warren Eugene Hansen. These estates are all listed on page 2 of the request as well. Although OVINTIV believes it has leased all such successors and voluntarily pooled their interest pursuant to the pooling clauses contained in said leases, there may be additional parties claiming buy-through under these estates that we must pool here today, given the incomplete distribution of the subject mineral interests. Pursuant to the board's order entered on December 12th of 2024, the requisite notice of opportunity to participate was provided to them partially in December, and in January 8th and January 15th today. Proof of such publication will be filed separately in this cause upon confirmation and before the board's hearing next week. Given the hearing examiner ruling on the oral motion to continue a few moments ago, the affidavit of publication will be filed prior to the board's hearing on January 22nd, and any responses, if any, to that publication will be confirmed on the record prior to the February 26th board hearing. It is anticipated that the board will address any objections to the request, if any, at that February 26th hearing. Of note, as reflected on Exhibit 16, before I move on, of these 3 estates named, one of the estates has reached out and since provided sufficient clarifying documents that they can be removed. That's the estate of Kelly Reese Claiborne.
Before you move on there, Mr. Mayo, the Patricia Brown, the Hansons, the Thunderbird, and the Eugene Hansen Trust, they are who you're pooling?
That's correct. Those are the known parties with an interest who have yet to participate. To be clear, both Thunderbird number 3 and 4, Thunderbird and the W. Eugene Hansen Revocable Trust, OVINTIV doesn't believe either of those parties actually own an interest, but there is some confusion in the record that makes it so that it's only fair to notify them and give them an opportunity to come forward and say, yes, we own an interest, here's how, and we'd like to participate. So yes, those 4 parties are the parties.
You've yet to hear from any of them.
That's correct. As reflected on Exhibit 16 and as discussed in paragraph 27 of Mr. Dale's declaration, the acreage-weighted average fee landowner's royalty for the subject well is 18.692,766,398%. And costs, including the plugging costs requested, are just and reasonable, and the risks incurred in drilling the subject well justify the imposition of a 300% risk compensation award in this cause. With that lengthy introduction out of the way, I'm going to turn to Mr. Dale to confirm the declaration testimony and some of the things I've said here today. Mr. Dale, can you hear me okay?
Yes.
Okay. You please state your name and we've got your business address in the declaration, so we're good. If you'll state your name for the record.
Yes, David Dale.
Okay. And what is your position with OVINTIV generally and how it relates to this unit?
Yeah, manager for the Rockies land team, which includes our work in Uinta. And I oversee all the land work within the Uinta Basin.
Okay. And I'm assuming that gives you some responsibilities over this particular drilling unit as well.
It does, yes.
Okay. Mr. Dale, you're aware of what's been filed as Exhibit 25, the declaration of David Dale in this cause. Is that correct?
Yes,
Have you reviewed, do you recognize the declaration?
I do, yes.
And have you reviewed it, all the terms within it?
Yes,
Did you execute this declaration or cause your counsel to execute it on your behalf?
yes.
Okay. Is there anything you would like to add or clarify to that declaration? I discussed a notice failure and the estate of Kelly Reese Claiborne. Anything you'd like to add relative to either of those?
No, those were the only 2 items, and I'm happy to answer any questions, but I felt like you addressed them.
Okay. Just before I turn you over for questions, can I have you confirm on the record that OVINTIV intends to respond meaningfully to any objections, if any concerns raised about notice between now and the February board hearing.
Yes.
Okay. With that, final question before I turn you over. In your expert opinion, are the terms and conditions of the joint operating agreement submitted as an exhibit in this cause and also attached to the request for agency action, are those fair, reasonable, and commonly accepted in the industry and in the basin in particular?
Yes.
Okay. I appreciate that. Mr. Dale, with nothing else, I'm going to turn you over to the division and hearing examiner for any questions.
Division?
Yeah, just a couple questions. These are some similar to some of the questions asked earlier, so I don't know if you saw some of those prior proceedings. In this instance, a well was drilled, I believe it was 2018, the well. Title on these wells, in your declaration, you indicate you had 2 title opinions that were from 2011 and 2012. Just, could you please just clarify? I mean, that's a little bit of a gap. That's 7 or 8 years there. Could you just clarify what you did between the execution of those title opinions, the certification date, and then what you did to make sure the parties that were noticed to participate in these wells were still accurately parties on record?
Yes. So those title opinions, I see that's the dated effective, and they were certified on around that time. And when I say certified, that would mean the date the last examiner checked the county records. So from the certification date until our publish, we engage with third-party contractors that examine public records and chain that title forward. As it pertains to all the working interest and royalty interest, we will have those parties' interest in our system already, because we are billing people and we're paying revenue. And typically when people have revenue coming in, they're quick to tell you if they're entitled to interest or if their address has changed. So I'm confident of those parties. Of the small percentage being leased, we did chain those forward, and those who are, we believe, the accurate owners are today.
All right, thank you. Yeah, I see there's not very many people. Right. So I guess there probably wasn't a lot of reason to do a lot more work there. I do have another question. This is just more of a, I don't know, formatting question. In my experience in oil and gas, I've always gone to an 8 decimal place. I just noticed when you guys report a royalty, it goes way out. Is there a reason your royalty rates are so accurate? I guess it's just an industry. I've been in the industry a long time. I just don't usually see that. I was just curious.
You're saying on the average weighted royalty?
Yeah.
That we do have a group internally that pulls those and calculates those in our system. And honestly, I just examine their work to make sure it's accurate, but I don't ever put it to whatever decimal place they send it to me on. Is usually what I keep it, unless I see modifications.
No problem at all. It just goes back to my Chesapeake days. Many years ago, I was always taught 8 decimal places. So
yes. Yeah.
I just was wondering. All right. With that, Mr. Dale, yeah, no further questions by the division.
Okay, thank you. I have a few questions, just understanding. I want to make sure I got this right. We have section 25 sitting on top of section 36. We have 2 wells in 25.
That's correct.
I showed the main, a horizontal well.
The Mamie and the Evans well, and I believe they both were short horizontal wells.
Okay.
1 mile.
A little bit within the section. And then in 36, is this the main well that we're talking about today, or is there another main well?
It was a different, I say Mamie. Mamie was there too. I don't know which one's right, but It's a different well.
Okay.
There's a short lateral, a 1 mile horizontal well in section 36 and 2 1 mile.
And this proposed well, or the well we're talking about today, is a 2-section one. Okay.
That's right.
Well, let's go back to these. So there was forced pooling on the Lake Bowen well in section 36, correct?
That's right.
And when we talk about conversion, what are we doing there? What's happening to the production in those 3 wells as we move forward here with this forced pooling?
Well, so the way I understand it, the Lake Borum well was drilled and began producing and was most likely payable on a 640 allocation. It was set
not
up,
spaced at the time.
I believe it was spaced at the time, but I'd have to look back through the request to get the
Okay.
exact information. And if you give me a minute, I probably could do that. 139.90.
Established 640 units.
Yep. So they were payable when the Lake Borum well was drilled, and then when the Mamie and the Evans were drilled in sections 30, 25.
Well, that's back in the day when we were doing the short laterals.
That's right. Those were short
640.
lateral, 1 mile wells. Then subsequent to those wells being put in the ground and starting to produce, OVINTIV, Newfield came in and said, we'd like to do 2 mile wells. And given the kind of way they wanted to develop, a conversion order was what they chose. And essentially it means that Lake Borum well in section 36 and the Mamie and Evans wells in section 25, those continue to pay on their 640 allocation until a 1280 well is drilled, the well that we're here talking about today, the Mamie 46H well. Once that well is drilled and starts producing, then the 3 existing wells, the Lake Borum, Mamie, and Evans, they all convert after the conversion date, which I think is December 1st, 2019 in this case.
Okay.
So from that date forward, any recoupment owed under existing pooling orders is waived, and all the wells are payable on
So,
1280.
so any recoupment is totally gone.
Totally.
History.
Yep.
Okay. I'm sorry, I just wanted to
No,
make
that's,
sure.
is that help? Did that clarify? Okay, good.
I guess maybe one thing I would add on that matter is, Mitch, I think you and I looked at that Lake Borum well, and due to the costs incurred to drilling and completion and the LOE on it and the production, that well does not ever appear like it'll hit the 300% payout penalty. So it's just further evidence of the financial and mechanical risk to these wells, but also with OVINTIV being the by far and large working interest owner in that well, we would be like hitting now 100% payout and converting. So it is actually to the benefit of the parties that did not participate, as well as the parties in the other sections that will come in. OVINTIV will take that hit when it converts automatically at payout or at conversion.
That makes sense.
I kind of thought that, but I didn't want to be so blunt.
Yeah.
Okay.
It's,
So-
you know, the benefits go to the party with the most interest, and the
Okay.
risks go to the party with the most interest as
Well,
well.
that clear. Thank you, Mr. Dale, to clear that up. So I just want to make sure I understood that. Okay. Okay, we were back with me. I have no further questions for Mr. Dale.
With that, I'll move on to Mr. Wall. Chris, you can hear me okay?
Yes, sir.
Okay. Mr. Wall, would you please state and spell your last name for the record?
Sure. Christopher Wall, and that's WOLL.
Okay, and will you please, what is your position with OVINTIV and your job responsibilities, both generally and with respect to this unit?
Yes, I'm a reservoir engineering advisor working this DSU as well as others in the Uinta Basin for OVINTIV.
Okay. Are you aware of and have you reviewed what has been filed as Exhibit 26, the declaration of Christopher Wall?
Yes.
Have you reviewed all the allegations in that declaration?
Yes.
And did you execute it or cause your counsel to execute it on your behalf?
Yes.
Okay. Does the declaration represent your full and complete testimony here at this cause, or is there anything you would like to add in the alternative?
Yes, it does, and nothing to add.
Okay, thank you for that. A couple final questions. The actual costs of the subject well, those are reflected in Exhibit 17. Is your expert opinion those were fair, reasonable, and necessarily incurred?
Yes.
And are those costs within a reasonable variance in your opinion,
Yes,
of the estimated costs?
yes.
Thank you for that. Was the subject well considered economic to drill under the 139, 134 order?
Yes.
And finally, do you believe the risks that you discuss at length in Exhibit 19 and in paragraph 9 of your declaration, do you believe those justify the 300% risk compensation award?
Yes.
Okay. With nothing further from me, I'll turn you over to questions from the division and board.
Okay. Yeah, sure. Mr. Wall, just for a little bit of clarification, in Exhibit 17 that was brought up, we have lease operating expenses of 1.2 million. Could you just explain what goes into lease operating expenses? What expenses would that cover?
Okay, so generally that's anything that we need to, as an operator, expend to operate the well. So that could be electricity, chemicals, water disposal, if we need to buy gas for heating or anything like that. Those sorts of types of expenses go into lease operating expenses.
So would that essentially be any expenses subsequent to well completion that are required to produce from that well?
So there is a difference between the capital expenditures and the operating expenses. So anything to complete the well to make it ready to produce would be a capital expenditure. Everything after that point, just so we can generally keep the well producing, is going to be an operating expense.
All right, thank you very much. And just another question we had. So this well is in a unit that already had 3 wells that we've discussed already. Those other wells were short lateral. This is a long lateral, the subject well. Now, could you just explain, maybe for clarification, what addition, you already had some data there, but what additional risks or unknowns were there in trying to drill a 2-mile long lateral as opposed to the couple of 1 miles that you already had there?
Yeah, so the 2 short lateral or the 1 mile laterals does help us understand what the structure is. Those are both targeting the Utah Butte formation. The well that we drilled, the Mamie 46H, as we're discussing today, targeted another interval, a little shallower, called the Upper Castle Peak. That's how we reference it here at OVINTIV. So that was one of the first Upper Castle Peaks horizontally drilled in the area. So a little less known about the structure, we can get a pretty good idea of drilling below it. The second thing is we were at the time experimenting with what we call spacing and stacking. So how close can we drill to other wells? In this particular case, we're drilling 1 new well above 2 older existing wells. That introduced some risks and understanding how the zones are going to interact with each other. And so that's another level of complexity that we added by drilling, a third horizontal or a 4th well in the DSU. My question.
Yeah, sorry, Peter Pankey with the division. Did you see a lot of interaction between those? I don't know. You probably weren't here when this was drilled. So this is just a geologist asking questions that are interesting to him.
Yeah, no, that's no problem. While drilling, no. I mean, didn't see any interactions, but upon the completion and subsequent production, we do believe we see a lot of interaction. And basically, this is a situation, a Thomas Edison moment, right? Where we learned what not to do.
So you don't do this anymore. Going forward, you guys don't stack them like this.
Yeah, we think this is probably a bad idea.
Okay. Yeah, I mean, that makes sense. That's why I asked the question. How far are those intervals apart? The measured depth between the two, just off your head.
I'm sorry, I don't have that off the top of my head.
Man, come on, where's your geological knowledge, Christopher Wolf?
I know, I'm so sorry. Sorry to let you down.
I'm just kidding. Thank you, though. I appreciate it.
Yeah, and with that, the division has no further questions, Mr. Wall.
Okay. Yeah, I think I have no questions for Christopher Wall, so we'll proceed back to the division now. I think I've already mentioned this, but we had a notice of non-opposition based on the notification. Anything you'd like to address more of that? Anything that's been well presented?
No, as we indicated in our response, the division as to the statutory and regulatory requirements outside of the publication area, the division has no opposition to the petitioner's request. Based on the solution that was provided by council today, the division is in support of this request going forward, with the sufficient time for any objections for the latter publication to be brought up before the board before the final order is approved.
Okay, thank you. We'll now take closing statements from the division and from the petitioner. Mr. Haynes, what you said is suffice.
Yeah, we have no further comment.
Okay, turn time over to Mr. Mayo.
Thank you, Mr. Rogers. Really not much sum up here. We appreciate the understanding and the flexibility. We try as hard as we can to keep these on a very steady linear path. Sometimes the world doesn't cooperate. And I really appreciate the division and hearing examiner's willingness to consider the continuance and grant it. Considering that publication has likely been affected today, and on the assumption that we will receive that confirmation from UIntiv Basin Standard today, I would argue that all the regulatory and statutory requirements have been met, and this pooling is now ripe for approval. And on that basis, I'd submit.
Okay, thank you. Okay, my summation. Having reviewed the request for agency action and all exhibits and having considered the evidence, I find today that I'll do a provisional acceptance of what we've done here based on the notice been published today, and we'll have a presentation in next week, Mitch, to explain to the board what's going on here.
That's correct. And just to put the hearing examiner's mind at ease, these are referred to a hearing examiner on two conditions that we're supposed to gatekeep. One is there's no protests, there's no objections. And the other is there's nothing novel or new. And this may feel a little novel or new, but I've done this several times before the board in other matters. So to the extent there's any concern about that, I just wanted to clarify. This is something they should have some familiarity with.
Okay, so it'll be provisional based on any kind of notice we receive in the next month from next Wednesday.
That's right, about 5 weeks.
And then we'll continue this till February.
Till the February 26th board hearing, where I would assume I'll report back
Just
any
as we
objections or
normally do.
not, and the board will.
And you'll notify us if, in the meantime, if any.
That's right.
Okay. Okay, so that on a provisional basis, I find OVINTIV have provided sufficient notice of opportunity to non-consenting compulsory pooled owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present with this well, and find that it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV have met its burden of proof to show that they are entitled to forced pooling of the named interest and other relief requested in a request for agency action. Mr. Mayo, will you prepare the provisional order, or will we wait till we actually hear?
It really is preference. I think either way, the order will need to be modified the week before the February hearing, just to make sure we've captured any objections, if any, or state that there weren't any objections. So if the hearing examiner would like to have a provisional order approved today or this week before next week, I'm happy to prepare one. If you'd rather just wait until the February hearing and do a provisional, acceptance of that provisional order, then I think that makes sense.
Yeah, I think we'll just wait till February.
Okay. I'll plan to prepare that and submit it a week before, around the 19th, the hearing examiner date in February for consideration.
Okay. Okay. Any other comments before we close?
Oh, thank you.
Oh, did we forget that?
I forgot that, to clarify. It was me. I would like to move for admission of exhibits 1 through 19, exhibit 25, 26, and 28. Exhibit 27, the affidavit of publication has not been filed yet, but will be filed prior to the February 26th hearing, and we'll move for admission of that exhibit at the February 26th hearing.
Okay, so just to repeat, that was exhibits 1 through 19, exhibit 25, exhibit 26, and exhibit 28.
That's correct.
Well, just for clarification, you will be here next Wednesday for your other matter. So we'll just clarify this in front of the board at that time.
That's right.
Okay. And it'll be prepared to do that then.
Yeah, absolutely.
Okay, are there any other comments or issues anyone would like to bring up? Okay. We'll adjourn this meeting at a time, and we just thank OVINTIV for participating remotely and yeah, thank you.
Thank you. Same two witnesses for the next matter, but they won't be doing much.
Okay. Okay, we ready to go, Matt?
You're ready to go.
Okay, thank you. Good morning. My name is John Rogers. I'm environmental manager at the Utah Division of Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner of this proceeding. Today is Wednesday, January 15th, 2025. And this is the time and place for the hearing examiner proceeding for docket number 2025-010, cog number 132-71, in the matter of the request for agency action for OVINTIV USA for order pulling interest, including the compulsory pulling of interest in certain non-consenting owners, the Pekovich, Utah 1-14, 4-3, -11-2-1-8 well in the drilling unit established for the protection of oil, gas, and associated hydrocarbons from Lower Green River-Wasatch Formation, comprised of all the sections 2 and 11, Township 4 South, Range 3 West, within a special meridian, Duchesne County, Utah. At this time, I'd like to turn the time over to Mr. Mitch Mail for OVINTIV, the petitioner. We've had some issues come up that would, I think, delay the hearing of this matter today, and I'll have Mr. Mail explain that.
Thank you, Mr. Rogers, hearing examiner. I appreciate that. As noted, in preparations last minute for this hearing today, there was essentially a notice failure that we believe warrants continuing this entire matter to the February docket. And we're sensitive of the board schedule and the division schedule, and also recognizing the inconvenience to the petitioner in having to remail the request and the confusion that may stem from mineral owners receiving a duplicate request a month later. Pursuant to Utah Administrative Rule 641-105-300, which says that oral motions can be made at the hearing, OVINTIV would hereby move to continue this matter to the regularly scheduled hearing examiner hearing held on February 19th. That would allow us sufficient time to essentially cure the notice issue and make sure that the matter is properly before the hearing examiner before we proceed. And so essentially, I'd like to move to continue this matter to the February 19th hearing examiner hearing so that it can be heard formally on the board's February 26th docket.
Okay, one moment. All right. Division, do you have any objections to that procedure?
The division has no objections. Over under R641-113-100 continuance. And I assume Council's going to do this, but let's also make this motion in front of the board on board hearing next week.
Yeah, I assume we would clarify it there too.
That makes good sense. Yeah.
Okay, well, upon that, I accept the the method for continuance of this. We'll notify the board and then move that to February, is it 19th? What's the next hearing date?
That's the hearing examiner scheduled hearing for February, and
Okay.
the docket is February 26th for the
Okay.
board.
Okay, we'll proceed in that matter for this last matter then. Anything else anyone would like to bring up at this time? Okay, thank you for everyone's participation, and thank you to OVINTIV for being there and being online. That's always helpful.
Thank you all so much.
Thanks, everyone.